Good afternoon, everybody. Thanks for coming. My name's Deborah Wolfe. I've been practicing in California for 42 years. The last probably 32 of those, I've been concentrating my practice in legal malpractice, representing plaintiffs in legal malpractice claims. I do have a specialty in legal malpractice law and also in civil trial practice. These days, I'm not taking cases. I am representing, or not representing, rather, I'm acting as an expert witness in legal ethics matters and also providing assistance, coaching, and trial strategy planning with attorneys. So that's kind of my background. Without further ado, let's launch into this withdrawal subject. It's one of those tricky things that we have when we have clients that aren't necessarily doing what we ask them to do, or there's all kinds of reasons, of course, why people want to withdraw, like, they're not getting paid. That's a big one. Non-cooperation, failure to follow advice, or doing potentially things that are going to be harmful to their case. So there's reason to withdraw. There's a couple of different things we're going to talk about today. Mandatory withdrawal is kind of number one, and we're going to talk about permissive withdrawal, and we'll get started going through this. Go ahead, Kathleen, put us on the next slide. Okay, so we look first for the rules of professional conduct. As an ethicist, that's the first place I always start because that kind of sets forth the minimum standards that lawyers have to follow. It's not the standard of care. When I testify, I say often that is below the standard of care, because if you violate one of these, you could potentially get disciplined by the state bar. So if you look at your state bar website, is a wealth of information and has all kinds of ethics information and answers to ethics questions. But it has the rules of professional conduct. As you know, the rules were changed, modernized to be more like the ABA model rules. There are some differences in California, but essentially the numbering system was changed from the way it was for 20 or 30 years before that. And now we use the same numbering as the ABA. So the rule of professional conduct that relates to termination or withdrawal of representation is 1.16. And you can see what it says on the screen there, except as stated in paragraph C, a lawyer shall not represent a client shall withdraw from the representation if the lawyer knows or reasonably should know the client is bringing an action, conducting a defense, asserting a position in litigation, or taking an appeal without probable cause and for the purpose of harassment. So in those things, if your client is doing any of those things, it's a mandatory withdrawal situation. Okay, next slide. So this is another situation where you must withdraw if you know or reasonably should know that it will result in a violation of the rules or the State Bar Act. And I've listed a couple here. RPC 3.1, 1.1, which is competence, and Business and Professions Code, section 6068 and 6100 through 6117. Those Business and Professions Code sections are known as the State Bar Act. And you can also find references to those on the State Bar website. Those are the bases that you can get charged by the State Bar for malfeasance. So those are pretty important rules to know as well. Okay, so go on. Okay, so Rule 3.1 talks about how lawyers have a duty, because in addition to the duties we have to our clients, we also have a duty to the court. We're officers of the court, and we have a duty of candor to the court. And we also have this duty of only bringing meritorious claims and contentions in our litigation matters. So we all know we can't bring it or continue an action or conduct a defense or assert a position without probable cause. That's potentially malicious prosecution, but not only that, civilly actionable, it is also a violation of our responsibilities as attorneys. And we shall not present a claim or defense that's not warranted under existing law unless you have a good faith argument that the law can be changed. So we all know that. So this is if you are being asked or forced, as it were, by your client to pursue a claim that you know is not substantiated by probable cause, you have a mandatory duty to withdraw from that representation. There's a couple of things you need to do first, but we'll get into that in a minute. Next slide, please. Okay, and this one is important, and it's one it's probably a subject for, countless more MCLEs about taking care of our emotional, physical health, mental condition, all that kind of stuff. And this is a really stressful job. We have a really high incidence of depression and anxiety in our profession. And, there's also a high degree of substance abuse, alcoholism, and so forth, more than just about any other profession, I believe. So that also plays into this termination of representation. And we have to know we're policing our own selves and following these rules. And we have to know if we're not in any condition, mental, physical, or otherwise, if it's unreasonably difficult to be effective in our representation of our clients and uphold the standard that we need to practice to, the standard of care, then that's another reason to get out. And you may decline or you may terminate representation if you are not mentally or physically well. And if you don't monitor yourself on that subject and you make a mistake, not only could you be subject to malpractice action, but also potentially state bar discipline. Next slide, please. So 1.1 is the competence rule. And this is where we're not supposed to intentionally, recklessly, with gross negligence, or repeatedly fail to perform legal services with competence. And they define competence as applying to the learning and skill and mental, emotional, and physical ability reasonably necessary for the performance of such service. And I've highlighted that. That's not highlighted in the rules on the bar website, but it's really important that there's a lot of pressure for lawyers to make overhead and billable hours and that sort of thing, but you really have to keep track of your own personal, emotional, and physical and mental ability to pursue a particular case. Sometimes a client, you don't have any problems with anybody else, but maybe one particular client is causing you emotional distress to the point where you feel you just can't handle it, and potentially it's damaging your representation of other clients. And you have to be the judge of that and say, look, I just can't do this. I've got to get out. So that's one of the other bases for a mandatory withdrawal. Next slide, please. So, of course, this is the easy one. If the client discharges you, that's a free pass and you get out. But remember this, and I've seen this come up in several situations, one that I'm acting as an expert witness in now, where the client was a corporation and the client, the principals of the client's company were, upset with the lawyers or felt that they, were not happy with some of the advice they were getting. And so they said, we don't want you to represent us anymore. So the lawyers subbed out. Well, you can't sub out in a litigation if you're representing a corporation. You have to have permission from the court, and you can't allow your client to represent themselves because, of course, only a lawyer can represent anybody in court other than themselves. And the corporation, as you know, is a separate entity and has to have counsel. So if you have a situation like that where your client wants you to get out of the case, you have to advise them, you can't represent this company. You're not allowed to. That's illegal. That's practicing law essentially without a license. And you are going to have to get permission from the court to withdraw if you're counsel of record, and they won't sign a substitution or find a new lawyer. So that's just something to keep in your mind if you represent corporations. So if you try to sub out without getting or having another attorney take over for you or without court permission, you have to explain to the client there's going to be a default if you don't get a lawyer for this company. Even if it's not me, you're going to have representation. And if you don't have representation, then the corporation's going to be out of this case. They're going to be defaulted. And of course, it's your responsibility to tell the client all the things that are going to happen if that situation comes to pass. Next slide, please. So one of the sort of loopholes, if you will, in 1.16 about withdrawing from representation, you might not be obligated if you're withdrawing for reasons that you have a conflict of interest, for example. You may not have to withdraw from representation in all of the client matters. It just depends on, if you have a conflict in one situation, we're in a litigation, for example, you may not, or your firm may not have a conflict in representing the client in a business deal or in a estate planning situation or something like that. But it's something that you just should be aware of. So if you have a conflict of interest under rule, actually I misstated that 1.7. Yeah, 1.7. I'm sorry, it's a conflict rule. So if you have a conflict of interest under that, you may not have to withdraw for all purposes, but you have to be aware enough to understand if a conflict is going to prevent you from continuing or filing a litigation matter with that client. Next slide, please. Okay, and this is what we were just talking about, the conflict of interest of current clients. Again, another subject for another day, conflict of interest. It's a huge area for lawyers to get sued for malpractice. I know that from personal experience. So if you're ever trying to represent more than one person, you should get a very detailed conflict waiver. And of course, before you even think about representing them, you should do an analysis internally to decide if you really can represent one client fully and with your duty of undivided loyalty to each one. It's very difficult to pull off representing more than one client, and it's got to really be at the forefront of your mind at all times if you're representing more than one person. And that means potentially a director of a company as well as the company. There could be a potential conflict of interest there. You have to, even if you physically have to get up and move seats to say, well, if I'm just this person's attorney, what would I do? Versus if I'm this other person's attorney, what would I do? And if there seems to be, some disconnect or some place where you might hurt one while representing the other, then obviously should not undertake that representation. But if it so happens that you're already representing multiple clients and this issue comes up where there's a conflict, because you can't act as an arbiter between the clients or a mediator, you have to have a single set of instructions. And you may have to withdraw from representation of both or all clients, however many you happen to have, if there's a conflict situation. So if your duties are going to be materially affected by helping one client and it's at the expense of the other one, that's a situation where you must withdraw. Next slide. So going back to 1.7, loyalty and independent judgment are the hallmarks, of course, of representation of a client. And this duty of undivided loyalty, if that duty is impacted by undertaking the representation or continuing the representation of another client, you don't have the informed consent of both clients, and that would be in writing and after advising them what the conflict could be, what the consequences of having a conflict could be, and advising them to seek independent counsel to determine if they should continue or allow joint representation, you're going to be in a problem. And that may be one of these situations where you mandatorily have to get out of the representation, probably of all clients, because the The issue is how much do you know that's confidential information? And that is kind of the defining line of whether you have a conflict that you can't continue representation of anybody. If you know something that potentially could be harmful to any of the other clients you've represented, the probability is that you would have to withdraw from representing all of them. Next slide, please. Okay, and so this just, it's kind of elaborates on what I just said, so we don't really need to go into it, but if you're going to have to struggle between representing the best interests of one client as opposed to the best interests of another, that's a situation where you should probably get out, and the law requires you to do that. If you cannot submit to this duty of undivided loyalty, then you have to get out. Next slide. Okay, so this is section B. This is where you may, in other words, you can continue to represent, but you may withdraw. And there's a whole bunch of different scenarios, many more than the mandatory withdrawal. Let me take a drink of water here. So again, if the client insists on presenting a claim or defense in litigation or making a demand in a non-litigation matter that's not warranted by existing law, you may withdraw. And I should say that before you even withdraw in a mandatory withdrawal situation, as well as a permissive withdrawal, you know, if your client's presenting some crazy arguments, and we've all had that, I'm sure, with clients, they don't, you know, they want item D and only A, B, and C are on the menu. And so, you know, you have to explain to them, and you have to tell them, you know, fully that, you know, the thing that you're advocating is not either not in your best interest, or it's against the law, or it's something that I can't do. You do have a responsibility to counsel them. You know, you should really take my advice, and here's the problem. And of course, if they're not listening to you, the standard of care requires you to put that in writing. And it's not, as some might say, a CYA. You are actually covering the client, making sure the client understands your advice, which is the standard. You have to communicate, and communication is a two-way street. So you need to put in writing to the client, and if they still won't do what they're supposed to do or follow your advice, you need to tell them you're going to have to withdraw. You're going to, it's, you know, if they don't, you know, follow your advice, you're going to need to withdraw, and what that will mean to them, because that's going to cost them a lot of money in many cases, most cases, to change horses in the middle of a case, or to, you know, in the middle of negotiations, or whatever the situation may be. And so that's something before you withdraw, even permissively or mandatory, you need to kind of have that discussion with your client so that they're fully aware, and not just to protect yourself, but also to make sure that the client understands what you're telling them. Many times clients don't like the advice we're giving. And when they're sitting in the room with you or talking with you on the phone, they're arguing their position. They're not really listening to you. And that's why Advocate and the standard of care requires that you put it in writing so that they have an opportunity to sit down without having that back and forth and thinking ahead, like, how am I going to argue with the attorney and do something different? They have this in writing, and they have to look at it and say, wow, my attorney put this in writing, this must be important, and make sure that they get that advice. So, because often this is a traumatic situation where you're withdrawing from representation. It's easy to say, you know, try to pick your clients better at the beginning, but sometimes, you know, we don't know. They put on a good front. We don't know who they are. And sometimes we get stuck with a client, or we're representing in a situation where we just see that it's not a good fit for whatever reason, and we need to get out. And so then it depends, you know, if the client obviously wants to pursue criminal or fraudulent conduct, those are also reasons for mandatory withdrawal. But if you look down, if the client by other conduct renders it unreasonably difficult for the lawyer to carry out the representation effectively, these are subjective. And so like I said, I think it's your obligation once you take the client on, you have that fiduciary obligation to, help the client to act in their best interest and to tell them what is in their best interest to do. And so if they're making it unreasonably difficult, you have to decide if that's something that you can fix, or if it can't be fixed, you need to get out. And then, if you're in a litigation situation, of course, and the client will not agree to allow you to get out, then you have to ask permission from the court to do so. Now, one of the things that we all want to avoid is a client not paying us. Because after all, if we're going to work for free, we might as well sit on the beach. We have that available to us in Southern California. So is it proper to withdraw from representation if the client isn't paying you? This is where that permissive withdrawal comes in. If you get too close to a trial date or a date that's going to be, extremely prejudicial to the client or to the other party, if you choose to withdraw, 2 weeks before the trial and everybody else is geared up and the other party has to go in, you're going to have to get permission from the court and understand that the reality may be the court may not let you out and you're going to have to proceed whether you're getting paid or not. So this is something you should kind of look in the future and try to figure out if you've got a trial coming up, give the client fair warning about what's going to happen. And if they, are unable to or unwilling to pay you, try to get out at a point in time where it's not going to prejudice them. And so you can see here's where it's in the rule that the lawyer has an obligation to give the client a reasonable warning. And of course, reasonable, any place in these rules where there's an asterisk, that means that the word or the term is defined in the rules. In the very first, in this first section, it's a sort of a preamble to the rules is all the definitions. So reasonable is defined as what a reasonably prudent attorney would do under those circumstances. So you have to sort of tell them, warn them, this is going to happen if you don't, fill in the blank, whatever it is. Stop calling me in the middle of the night, pay my bill, be respectful of my staff, whatever it happens to be. You have to give them a fair warning, but we're not slaves. So there is a provision here, and you can make your case to the court about why you need to withdraw. I mean, the court ultimately is going to have the last say. If the client, objects to it, you're just going to have to be prepared to say you have done everything you can to minimize the impact. Next slide, please. Okay, and so here's some more reasons why you might be able to withdraw. You have a permissive withdrawal. If the client, of course, freely assents to termination, and that is, you have to make sure, even though the client says, yeah, okay, I'll let you out, you have to make sure that you let them know what is coming up, what deadlines there are, if there's something that has to be done more immediately. When you're turning over a file to another attorney or the client, you need to go through and tell them what they need to know so that there's a smooth transition. And the ultimate consideration is, are you prejudicing this client by your withdrawal? And that's what you have to try to avoid at all costs, is prejudice to the client. So, again, the mental or physical condition renders it difficult, or if your continued representation, you're going to violate these rules or the State Bar Act, including, criminal conduct and that sort of thing. And you can also, they've gotten this sort of omnibus catch-all section, if you believe in good faith that the tribunal will find the existence of other good cause for withdrawal. Next slide, please. Okay, and this is sort of what we said. If the court permission for termination of representation is required by the rules of the tribunal, you can't terminate without permission of the court, of course, of the tribunal. If the client won't consent and you want to withdraw, you have to file a motion requesting the court's permission to do so. Next slide, please. And this, of course, goes back to what I said. You can't terminate representation until you've taken reasonable steps to avoid any reasonably foreseeable prejudice to the client, giving him enough time to seek other counsel. Sometimes these things come up. Like I had a situation where I had a client, I sat in his deposition, defended his deposition. He made, certain statements in his testimony. We got out of the deposition, went back to my office, and he informed me that he had lied under oath at his deposition. So I needed to, we were pretty close to trial at that point. I couldn't, do anything about the fact that he had lied. I told him, I don't think I can put this case on without putting you on the witness stand, and I can't put you on the witness stand because I know you lied. And so in withdrawing from the case, I went to the court, presented the court with the request to withdraw, and only said in my declaration, it is a mandatory withdrawal, Your Honor. And, there's sometimes judges will say to you, well, you can just tell me in camera. We will do it outside the presence of the other lawyer. No, you can't, because that's confidential. You have a requirement to maintain the secrets and confidences of your clients at every peril to yourself. That antiquated language is still in the State Bar Act under 6068E. And, you can't tell anybody, including the judge, and maybe especially the judge, particularly if that client is going to get other counsel and try the case in front of the judge. So you're caught on the horns of a dilemma, and you just simply have to make that representation. I'm going to show you a case that's a COPRAC opinion later on that's going to kind of underscore the impossible situation that creates for a lawyer. If the court, for example, says, I'm not going to let you out unless you tell me why, it's a very difficult question to answer as an attorney, but sometimes that kind of stuff comes up. So in that particular case, we were coming up to the trial. I think, like I said, it was in a couple of months. And I said, I need to withdraw, but I need to make sure that, the client's not going to be prejudiced by this. And I'm going to ask the court to provide us with 6 months so that new counsel can get up to speed. And the court, to his credit, was a very astute, very ethical judge and said, yeah, I have to, based on counsel's representation, I need to allow her to withdraw, and I will continue the case for trial so that the client has enough time to get another lawyer. That is the best of a bad situation, I guess. Nobody wants to have to withdraw at that point, but sometimes you have to. You cannot put on perjured testimony. And I couldn't win the case without the client on the stand. So that was my problem. Next slide, please. Okay, and so I've quoted some cases to you here, did some research, Westlaw research, and there's a lot of fine points in these issues. Most of this case law I found comes relative to an attorney who has withdrawn from representation with a contingency fee agreement and then wants to get a piece of the fee because some other lawyer has come in and gotten it. And even though the client, the fee is going to come out of the other attorney's share versus the client's share. There's a lot of pushback, as you might imagine, in a situation like that. So whether or not you can withdraw and still collect a fee turns on this issue of whether or not there was a good cause for the attorney's withdrawal. And in this case from 2003, Russ Miliband Smith versus Conklin Olson, the court found in that case the law firm's withdrawal from the case wasn't sufficiently justified to warrant a quantum merit recovery. That means you withdraw, and essentially, the bottom line with these cases is if you withdraw from a case where you're representing a client on a contingency, and there's a number of reasons why one might want to, unless it meets these factors that we're going to go into in a minute, you're not going to get a fee. And you really, as the attorney withdrawing, are going to have the burden of proof And as I said before, you can't compromise the client by revealing attorney-client privileged information. So that kind of ties your hands behind your back. Even in trying to get the fee, you're not allowed to do that. I mean, the only time you really don't have to maintain the privilege is if the client is suing you for negligence in your representation of that client. Then that attorney-client privilege goes away. And the statute says only to the extent necessary to defend yourself. As a practical matter, though, having done these cases for, practically my entire career, that includes everything. So whenever, a client wants to sue an attorney, that always has to be part of my statement to the client. The attorney-client privilege is off, and so they're going to be able to bring up anything that you said to them that may not make you look so good in the malpractice case. So let's talk about that. But otherwise, when you're withdrawing or even trying to get your fees in a situation such as the one that's presented by this case, you can't reveal your client's secrets. You just can't do it. So if you withdraw, you feel you had good cause to withdraw because it falls under one of the mandatory reasons. Client wanted you to violate your oath as an attorney or some of the rules or commit a crime. You have the burden of proof to show that your withdrawal was mandatory, not permissive, that the overwhelming and primary motivation was to adhere to ethical principles, that you commenced the action in good faith, that the client obtained recovery after withdrawal, and counsel demonstrated that his work contributed in some measurable degree towards the client's ultimate recovery. And again, you have to do this with your hands tied behind your back because you can't talk about what exactly your client said that made you feel like you had to mandatorily withdraw. So as I said, as a practical matter, if you withdraw from representing a client in a contingency fee case, that's pretty much it. That's the death knell for you getting a fee. Not that you can't get out, you can certainly get out. But if you try to go back and get the money that you otherwise would have been entitled to had you stayed in, the likelihood of your getting that is slim to none and slim left town. Next slide, please. So this was another case, Estate of Falco, and this was before the rule change. So the rules that this court relied on were different. They were numbered differently. And there's quite a few. If you have an interest in finding out what the rules used to be versus what they are now, on the State Bar website, there's actually a table that you can look at that sort of tells you what the old rule was, what the new rule is, and you can look at they have all of that information on there. There's some things that there was no corresponding former rule, like the 8.4.1, for example. A number of those rules were not in existence before. All the 5 series were not in existence before, so those are kind of new territory. But in this case, it's the same thing. In this case, the court allowed the attorneys to recover their costs in a situation where they withdrew and tried to plead their case for why they had to withdraw. But he would not allow them their fees because these were the findings, and he went through all the elements that the last case we discussed said. And one of the things I thought was important to note about this case, the client's refusal to settle in itself can't constitute cause for withdrawal. And so, the client, you want to settle, you tell them the client's in the best interest, it's going to cost more money to go to court than you're going to get in your pocket, and all the myriad reasons why you're giving the client the advice to settle, and they refuse. That alone is not going to constitute good cause for your withdrawal. So I don't know, like I said, when in looking and drilling down in these cases, I think it's pretty hard to make a case for yourself to get paid if you withdraw. Next slide, please. Okay, so this is one other case, Ducrow versus Forrest, and that's a 2013 case. So this is a case where the attorney withdrew and tried to get their quantum merit for good cause at the beginning of trial, and the court held that when the attorney withdraws for ethical reasons, the attorney has the burden to show that the counsel's withdrawal was mandatory and not permissive, and that the overwhelming reason for withdrawal was the adherence to ethical principles. So again, and the right to withdraw is different than the right to withdraw and subsequently recover your fees. Next slide, please. Okay, so I've put some forms together here. You might want to magnify this, Kathleen, if you could, so that they can see it. This is a family court form withdrawal. And so, you know, this is something that a family lawyer might want to file that they're withdrawing. And that's, you know, in the situation where the divorce is over, or, you know, for whatever other reason you're withdrawing. It's a special form relative to family court. And I'm not sure, because I'm not a family lawyer. I don't know what the protocol is there. If once the case is over, if you actually have to withdraw, the case is over. One of the reasons that as an attorney, you may want to fix the date of your withdrawal. Your client is only going to have a year, in most cases, I'd say 95% of the cases, to come after you for legal malpractice. If they feel that that's one of the reasons that you got out or one of the reasons you weren't getting along. So you want to make, as an attorney, a bright line where your representation terminated, and then do no more work for that client after that happens. That basically starts the 1 year ticking. So just as a practice pointer, I would say that if you're not representing somebody anymore, you either file, if the case isn't over, you file substitution on a particular date, and you also write a letter advising the client that you're terminating, you know, the representation. And I always think it's a good idea to put the reasons in there as well. And you know, then there's no question about when the end of the representation happened. Like, I stopped doing work, but I didn't withdraw until, you know, a couple months later, or, you know, vice versa. You withdrew, but then you continue to provide advice to the client in pending them getting new counsel. So it's just as a practice pointer, you might want to do that. Next slide, please. Okay, so this is in civil court if you want to withdraw as attorney of record. And this is a required judicial counsel form. Before, and these forms weren't always in existence. You had to go through and file a motion and appoint some authorities, as well as a declaration and all that. And there were so many instances, I think, is what prompted this pursuit, that the Judicial Council just came up with a series of forms. You have this notice of motion. I'll show you the next one, which is a declaration, and then an order. And so you don't have to go into all the reasons. The court, you know, the judges know what the basic terms are of why somebody withdraws and whether or not there's good cause. And so this, if you're trying to withdraw from the case, this is the form that you need to file and fill in all the applicable points. And you say this motion supported by, under number 3 there, this motion supported by the accompanying declaration, papers on records on file in this action, and the following additional documents or evidence. And again, anything that you want to include in that, you have to also keep in mind that you can't reveal your client's secrets, and you can't do anything to prejudice them in terms of the other party, their position in the case, the court. You know, I've had situations where a guy wanted to withdraw. I mean, I understand why he wanted to withdraw. The client was a real pain, but he was a month away from trial. He had made a bad deal for himself and how much he was going to get paid. And he just, you know, wanted to withdraw, and the client opposed it. And the court said, well, you're too close to trial. I'm not going to let you out. So the lawyer then filed a quote unquote motion for reconsideration and listed chapter and verse about he's getting out because the client's a liar and none of this stuff really happened. And so then, needless to say, he got sued. That's why he was on the other end of a malpractice breach of fiduciary duty lawsuit, which is different than just negligence. That's when you violate one of the rules of professional conduct that then harms your client. This client had to go and get other counsel to come in and pay them, and the trial got continued. The judge had to recuse herself because now she's prejudiced, a whole bunch of stuff like that. So it's just not it's very delicate to try to withdraw anyway, because then you are opening yourself up to potential liability. So you got to make sure you do it right, and you're not prejudicing your client, and you're not revealing any of their secrets. So this number 3, whether you want to include anything in there or not, it's up to you. But again, maintaining in mind your responsibilities as counsel. And you can, you have to tell what the client status is. Go on to the next page, please. Yeah, this just tells you what their status is. Next slide. The second page of this form, let's see if we can zoom in on that. Thanks, Kathleen. So this tells you what you have to do with the client, and the court has put this into the moving papers so that they are assured that when the client does get served with this, that they are aware of all of these points, telling them that you can't represent yourself if you're a guardian, a conservator, a trustee, corporation, all of those things. And telling them what's going to happen if the motion is granted, and basically setting forth all of those things. Now, you're going to have to personally serve that on your client. Obviously, if you're withdrawing, your client's not substituting you out, it's going to be a really tense situation. I think of very few situations where it wouldn't be when you're withdrawing, and that's, of course, why you're all here. And there's no easy answer to that, but you do have to make sure that the client's served. If they're evading service, then you have to follow those rules that you would, as you would in any other situation where the client's evading service, and perhaps substitute serve them, follow it up with a mailing, send it certified, as many ways as you possibly can, being very reasonable and trying to make sure that the client has enough notice. And you've got to be able to prove to the court that you've done everything you can to provide proper notice to the client, because the judge wants to get it right too. Okay, next slide, please. Okay, and here's the declaration. That's a form also. And again, it has places for you to sort of fill in the blanks, but you have other responsibilities. So the reason for the motion, and you're going to have to say, mandatory, and cite the 1.16 and say that, that whether the representation has become unreasonably difficult, you've had a difference of opinion, whatever it is, you're going to have to make your declaration within the confines of your ethical obligations as an attorney. And as I said, if you try to make these decisions early on versus waiting until the last minute. There were situations with some people who I don't really have to name, who was, stealing clients' money, but he was also doing things like, blowing deadlines, and things would come up, and he would just, basically try to get out, and created a big problem for everybody. So you want to make sure that you're withdrawing for reasons that are approved ethically, and that if it's a mandatory versus permissive withdrawal, and you're making sure that the client is not prejudiced by your withdrawal, because then the court's got to make that call, and they're relying on you as an officer of the court, who essentially is always under oath, to be truthful in telling them there is a reason that you have to withdraw, and you can't reveal it because you can't compromise your client's rights. Okay, you want to go further down this page. Okay, so this talks about the service, and you're making a declaration under penalty of perjury that the service has been done. If you have to attach other papers and whatever, reveal whether circumstances there are why you need to get out. it's possible that the judge is not going to let you out in a situation where you feel you have to get out, and you may need to bring a motion for reconsideration, but you still are going to be tied by those ethical considerations. Next page, please. I always want to make sure that you have the second page, because it does have some additional information that you have to put on there. Again, to make sure that the client's rights are not at risk. So, if you can't confirm, then you have to show where the client is, because a lot of times people have to withdraw because the client just becomes non-responsive to them. Won't answer your phone calls, won't answer their mail, won't answer your emails, is completely just ghosted you and goes off the grid. And you have to get out because, of course, they've made it unreasonably difficult for you to continue the representation if they won't talk to you or won't cooperate with you. And so you need to tell them, the court, what efforts you have made to try to get this person to respond to you or whatever it is. And you say the contact, person's familiar with the client. I mean, you really have to go above and beyond, because now you're dealing with somebody, and the court's dealing with somebody who's not even going to participate in the process of the withdrawal. So, and you want to have this too for future reference. Should somebody come back and try to sue you for malpractice, you want to be able to show that you've moved heaven and earth, you've done everything you could to protect their interest, and be able to back that up with facts, with emails, with certified letters, those sorts of things. So whatever you can do to keep in your file to show that you were very reasonable and you did everything you could to uphold your responsibilities, the better off you're going to be. The more likely you're going to be able to get out, and the more likely it will be that you will be able to defeat any claims against you. Okay, let's go on to the next slide, please. Okay, so here's the order. And again, this is something that you fill out and you have the court review it. You're probably going to have a hearing. Many times you'll try to go ex parte, but of course you're going to have to give statutory notice on these things because it is a pretty drastic remedy. So then, you fill in as much as you can for the court, and then the court and the clerk will fill out the rest of it and provide it. But this is the order you need to provide. This is the Judicial Council approved form, and this is the one you need to use. So next slide, please. And this is page 2, which again has all those caveats, those warnings to the client, to the person. We're trying to protect people's rights as much as possible, and also, to limit the court's exposure, and possibly the opposing party is going to be prejudiced by this. And so the court has to look out for their interests as well. And so that's why all the I's have to be dotted and the T's have to be crossed, and everybody has to have notice, because it's not a great situation. You want to try to avoid that, as I said, by being very careful in your selection of clients. And if you're worried about getting paid, make sure that you make those arrangements and make sure that you nail that down early so that you don't have to withdraw. You can even tell the client as part of your fee agreement, and most of us do, that, one of the grounds for my withdrawing from your representation is your failure to pay my fees. And, I have an evergreen retainer myself, meaning, the client always has to be ahead of me in terms of what's in my trust account. So I'm going to have some prior warning if there's going to be a problem with getting paid, because you want to be able to tell the judge, you've done all these reasonable things to try to prevent this from happening, but your client either can't or won't fulfill their obligations to you, and therefore you need to get out. Next slide, please. Okay, here's another source of information I wanted to tell you about. And let me just make my plug. If you haven't heard me say this before, I think I say this in all the ethics presentations I make. Please read the rules. Take a few minutes. It takes maybe an hour, and don't skip the comments. because the comments after the rules are very helpful in terms of how these rules are going to be applied, how to determine whether these rules do apply to you in a certain situation. And it's really kind of helpful to do that because every attorney in California is expected to be an ethics expert to the extent they know what these rules say. Because if you violate these rules, which are minimum standards required to practice law, you could potentially lose your livelihood. And nobody wants that. We don't want that. You don't want that. So if you look on the State Bar's website, under the attorneys section, there's tons of information. There's these COPRAC formal opinions, also the LA Bar Formal Ethics Committee, San Diego County Bar, and San Francisco, and I think, I'm not sure how many, I think Sacramento. There's several different bar associations that have legal ethics committees. I've been a member of the San Diego County Bar Ethics Committee since 2006. And, we've also put together opinions, sometimes based on questions that, come from our membership. What does somebody need guidance? Now, these opinions are located on the State Bar's website. You can do a search. They have a pretty easy search engine on there that will get you to ethics opinions. And they're not binding on anybody. The courts will look at them as guidance, so to speak. And they're very, very helpful in terms of, because the Ethics Committee, COPRAC is our State Bar's Committee on Professional Responsibility and Conduct. That's what that stands for. And they're the ones that kind of, do all the work on formulating the rules, formulating these opinions. And so, they come up with these hypothetical situations, usually based on something that happened, and will try to provide guidance to the practitioner. And it's very helpful. Because there's a lot of situations in there. Going back years and years and years. 2015-192 was an opinion that came out in 2015, and it was number 192. That doesn't mean there's 192 opinions. It means, because sometimes an opinion will come up, they'll put a number on it and they'll decide not to issue it. But this is how you locate these opinions. And this is the one that I thought would be most helpful to you. What information may you ethically disclose to explain the need to withdraw, particularly in the face of an order by the court saying, well, you need to tell me. I just need to know. I can't take your word for it, sir or ma'am. I need to know. You need to tell me why and what's the client doing, and you have to resist that. Next slide, please. I kind of had to laugh when I saw this opinion because it's really, I don't know how helpful this is. It says you may disclose only as much as reasonably necessary to demonstrate the need to withdraw, and ordinarily it's sufficient to say words to the effect ethical considerations require it. So if your judge is being, sort of recalcitrant and saying, I need to know, you need to tell me, you can show them this opinion and, perhaps they'll lay off of you because, whether they're the judge or not, there's still somebody outside of the attorney-client relationship that is not entitled to privileged information. And so it says the rules say that an attorney may not disclose confidential communications with the client, either in open court or in camera. And so this was written in response to, I think there was a specific situation where this happened. And so, while the State Bar can't tell the court or a particular judge what to do, they obviously want to, let the judge know that this attorney has ethical obligations and you're putting them in a real bind by trying to force them to tell you why they're withdrawing. And that's what they say. The committee can't categorically opine on whether or not it's acceptable to disclose them, even when faced with an order, because now you have that battle of the rules of professional conduct. As an attorney, you're required to obey court orders. You have to obey orders of the court, but you also have to, at every peril to yourself, which can mean, punishment by death, I guess, you cannot reveal the secrets of your client. So what are you to do when you're locked in a situation like this And you may, take avenues of appeal. You may take a writ. I really don't want to do this. And then it says, the attorney must make reasonable steps to minimize the impact of the choice on the client. I would think it would also include telling the client, look, this judge is trying to hold my feet to the fire. And if you don't just consent to my withdrawal, I'm either faced with, a contempt citation because I didn't reveal this, or, not getting out and, I don't think I can effectively represent you because, and whatever the reason is that you feel you must withdraw. And so that requires yet another conversation with the client, preferably in writing again, because God forbid you get brought up on charges for the bar for violating a court order because you chose, to not violate your client's confidences instead. And you want to be able to have as much firepower as you can. So this is a nice opinion to have in your pocket. But again, you need to make sure you try to minimize the damage to the client. And that usually requires extensive communication with the client about why you're withdrawing and why they should allow you to simply withdraw or substitute another attorney, and how it's going to affect them if in fact, you're forced to withdraw or reveal their confidential information. Next slide, please. So this obviously relied upon the old rules that were in effect prior to November 1, 2018, and the Business and Professions Code that we talked about also. But the new rules on these particulars are not that different than the old rules. So the same considerations apply. Next slide, please. So they came up with another opinion with the new rules, 2019-200. And of course, because, these opinions unfortunately can't solve anything definitively, and they can't basically tell any particular judge or court what to do. So these are the issues that they are considering in this opinion. What are the attorney's duties when the attorney suspects but does not know a client's witness who's expected to testify at a civil trial testified falsely at the deposition in the case, albeit favorably? And of course, your client, that puts a stress on you because your client doesn't want you to say anything because this was favorable testimony, even though you now know it's a lie. So let's, make this hypothetical situation as dire as we possibly can. So what are the attorney's duties when the attorney knows more than merely suspects the same witness has committed perjury and the client instructs the attorney to use the witness's known false testimony on the upcoming civil trial? And then the issue number 3, the facts are the same as issue 2, except the attorney first learns of the perjury after the witness has testified. What are the attorney's duties if any other attorney has gained now, if any, after the attorney's gained knowledge of the witness's perjury and the client's nonetheless instructed the attorney to continue to use the perjured testimony for the remainder of the trial? Next slide. So this is kind of the digest, and if you want to, review this further, you can look up this opinion on the State Bar's website and read all of the, the reasoning that COPRAC put into coming up with this ultimate conclusion. They address directly. You have to vigorously represent your client. And sometimes, you offer testimony to vigorously represent your client. Maybe that particularly comes up in a criminal defense situation. You have higher responsibilities and you've got clients that are facing incarceration or other criminal penalties. But on the other hand, you can't use false or perjured testimony. And those are all in the rules of professional conduct, and those compete at times and in the fact situation that they presented. So it says if you have to take reasonable remedial measures to correct the record without violating the duty of confidentiality. And if measures fail, you may have a duty to withdraw from the representation. And this goes with these rules 1.16, 1.6, and 3.3 of the rules of professional conduct. And 1.6, of course, is that rule that's very similar to 6068E of the Business and Professions Code, which demands that you maintain the confidences and secrets of your client in all privileged communications. So 6106 is also, it's kind of a catch-all. I occasionally will act as the special deputy for the Office of Chief Trial Counsel of the State Bar when the State Bar has conflicts in pursuing a particular attorney for one reason or another. And 6106 is often used as a charging allegation. It's the one where an attorney cannot lie, cheat, or steal, basically. It's moral, what is the moral turpitude? You can't commit any act of moral turpitude, and that covers a wide range of issues. You know, if you lied about the odometer setting on a car that you sold, I mean, you know, it can be as simple as that. But there's, you know, there's a big ocean of conduct that can come within that particular charging allegation. 6106 and 6128 is the one that says, if you lie basically about anything, you are guilty of a misdemeanor. So not only because you're supposed to be under oath all the time. So that's why I bring that to your attention. Next slide, please. So that's kind of the end of my presentation here. I appreciate your listening. I see that there's some questions in the chat. And let's see. Okay, I see them. I'm not sure I'm going to be able to get to those today, but you have my email address here. And if, you know, and this is what I do, I consult with attorneys about ethical issues because I'd rather help you now than try to, you know, have you dig yourself out of trouble later. So please email me, and I see that there's questions here. If I can't get to them, and I'm not sure, I guess Kathleen could probably send them to me, but just feel free to email me, dwolfe@wolfelegalsolutions.com, and I'll do my best to respond to you, at least to the best of my ability. It's hard, you know, these are not, I don't know, carved in stone, and it's hard for us to know when you're not constantly thinking about ethics. As us ethics nerds constantly are thinking about stuff like this. I'm not trying to scare you. I want to help you, and I want to help you help your clients. So thank you very much for your attention, and have a great week.